very happy to be with you today, and I hope we can have a nice chat. So you see, there is a list of very broad topics, but it's just a tentative list, meaning that we can skip back and forth as you please. If you have any questions, no problem at all. I don't know, are there any archaeologists in the room today? Yeah, perfectly. So probably you are familiar with what I'm commenting with this slide. The situation is very difficult in terms also of gathering data on the criminal phenomena in this field, trafficking in cultural property, especially trafficking in antiquities, because these are all crimes with a so-called huge dark figure of crime, meaning that the number of unreported and unrecorded crimes is far bigger than the ones we get to know officially. But this is an even more serious issue when we speak of antiquities, because oftentimes, obviously, the criminals are the ones to discover the objects first, the archaeological site first. So by definition, those items can never be inventoried. And then when we speak of museum collections, then we have the problem of them being badly inventoried or not inventoried at all. But overall, this is a big problem, not only for the police forces, not only for experts in the field, but for the lawmakers. If a lawmaker wants to make an informed decision, well, in this field is really hard because we lack a lot of data. Also, we know perfectly well that this market for artworks and antiquities, collectibles of any kind, has always been transnational, and even more so today, because if there is time, I would like to address the new specificities related to the growing of the e-commerce, of the online trade. And we will see that the growth of online trade has affected archaeological sites even more badly than in the past. Anyway, obviously the fact that the market is transnational means also that different states all around the world have different approaches to regulation, depending on their position on the market. The so-called source countries, like Italy, they tend to have a very strict, pervasive regulation, also use criminal law a lot. The so-called market countries, be them final importer or transit countries like the United Kingdom, Switzerland, and the usual one we know, they tend to have a very light touch approach, not too much regulation, no specific criminal law provisions. So it's quite difficult also to have cooperation working without extremizing this distinction, because yes, Italy is a source country. It has always suffered the typical problems of involuntary export of cultural property of all source countries like Egypt, Turkey, and so on and so forth. But what drives the demand on the market, on the transnational market, is relative scarcity. So Italy, for instance, is an importer state for artworks or antiquities from South America, the Middle or the Far East, and in fact, we have a specialized police force, the Carabinieri Command for the Protection of Cultural Heritage. Each year they publish a report on their activity, and each year there is a long list of items they have recovered and helped return to countries outside Italy, within Europe or in different countries, because we are importers of these items too. But it's true that Italy always was very rich in artworks and antiquities, and quite early interested in keeping this rich heritage within the territory of the Italian states. Because even before Italy became a unified state in 1861, many of the Italian states already had in place some elements of legislation protecting, even through criminal law, the cultural heritage, especially the papal states, but not only. And in fact, it could appear strange that the first Italian law for the protection of cultural heritage was adopted, well, the very first step was taken in 1902, but the first comprehensive law was adopted in 1909, and mark the date because this is important. A provenance before or after 1909 in Antiquities is very important in Italy. And then also the criminal law was used to protect cultural heritage, but possibly not as much as you would imagine. When the criminal code, which like in all civil law countries is very important also from a symbolic perspective, was adopted in 1930, it's the still in force penal code today, there was one provision only, a misdemeanor, for the protection of cultural heritage. Later, in 1939, a set of two laws, specific laws, were adopted for the protection of landscape assets, on the one hand, natural beauties were called at the time, and what we now call cultural heritage, so artworks, antiquities, and the like. And these two laws made a huge use of criminal law provisions. Still, they were not the penal code, so this symbolic relevance was missing. When Italy, after World War II, adopted a new constitution, this was an important step in our field because Article 9 specifically stated a clear duty of Italian government and authorities to protect the national cultural heritage, which in a way is also something that lends support to the more use of criminal law. When you are balancing competing interests, the fact that cultural heritage is protected by the Constitution makes easier for the lawmaker to use criminal law a lot. In fact, in the 90s, a few more provisions for the protection of cultural heritage were introduced in the criminal code. Those one focused on damage, destruction or damage. So damage to the physical thing and through that damage to the cultural significance. But the system was still mostly relying on specific legislation. There were a number of amendments, changes, and then we arrived in 2004 to the so-called Cultural Heritage Code, which is in force today. There were no major modifications to the criminal law protection of cultural heritage, not stemming from internal inputs. The two major reforms were undertaken in 2009 because Italy had ratified two international treaties, the second protocol to the Hague Convention and the Underwater Cultural Heritage Convention. And then we introduced new criminal offenses for the protection of cultural heritage. Only in 2022, there was a comprehensive reform of criminal law aimed at protecting cultural heritage, mostly because of, once again, international obligations we had to fulfill. The fact that Italy has ratified the Council of Europe Convention for the protection for offenses against cultural property, and it's a member of the European Union, but also answering internal inputs. So we have this huge body of public law protecting cultural heritage, whose main traits, features, are still the same from 1909. Some basic features remain the same as of today. the fact that cultural property, which is in the ownership of the state, regions, territorial public bodies, public museums, even not-for-profit private entities, is basically inalienable. So can never be legally sold or donated or bequeathed or whatever. And the fact that since 1909, any archaeological finding in the soil or underwater in territorial waters is automatically by law in the ownership of the state, meaning also that it is inalienable. Then we also have a tradition of very strict export controls. So almost everything needs to be authorized before being exported, and things which are in public ownership can never be permanently exported legally. The only exception is the so-called contemporary art exception. So if something is the work of a living author, or it was produced no more than 70 years, it was 50 years for a long time, now it's 70 years, it can be basically freely exported. You must actually tell the Ministry of Culture you are going to export it, but it can't be stopped. These obviously impact a lot on private interest, the interest of the private owner, but the Constitution allows it. Because on the one hand, we have this Article 9 that sets the duty of the state to protect the national cultural heritage. On the other hand, in Article 42, we have the protection of private property, but in balance with the protection of public interest. So Article 9 sets a public interest. Obviously, the system is geared towards conservation and protection first. The law, the Cultural Heritage Code, sets as a task for the state, in compliance with Constitution, also the enhancement and the public enjoyment of cultural property, but provided that they do not go to the detriment of protection and conservation. So this framework allows for use of a lot more criminal law than in other countries. Nonetheless, it may be surprising, but till 2022, overall, we had such a big number of criminal law provision, but the system of criminal law protection was considered weak, extremely weak. They were mostly misdemeanors, so lesser offenses. Even more, they were punished with very low sanctions that were considered enabled to deter especially the market side of the trafficking. They were very difficult to apply in practice because the criminal law part was very strictly intertwined with the administrative law part that was and is very, very complex, which makes things difficult also for the citizen who wants to comply, because the rules are not always so very clear. So it is not surprising that actually in Italy there were many law reform proposals, really in the dozens through the decades, none of which succeeded till 2022, when there was also a strong external input. You possibly know these things better than me. So Italy had good historical reasons to take this approach. There were sort of historical traumas that justified. So for instance, when Tuscany adopted the first law about export of cultural property, it was because a few decades previously, the Duchy of Mantua had lost most of the royal collection that was sold to the Kingdom of England, to the King of England, actually. And that was felt not only by the cultivated people, but there were also displays of sorrow by the population. Also, obviously, especially the Napoleonic campaign brought a trauma to Italian states. In that case, the Antiquities, the artworks, were taken as war spoils, then sanitized through the peace treaties. But in the end, at the Congress of Vienna, it was also sanctioned the principle that those kinds of takings were not compliant with customary war laws as they were being formed at the times. And in fact, Canova was able to bring back at least the majority of the papal states' antiquity. Canova was also consulted by the British Museum about the Elgin marbles, and he said enthusiastically, sure, buy them, keep them. So the double standards was being formed at the time. And then, of course, World War I and especially World War II also strengthened this idea that more protection was needed. We are, as you know, as also Poland is, still in the process of recovering many artworks and antiquities that were taken by the Germans during World War II. And it's even more difficult to recover the items that were taken from private individuals or families, especially the Jews. And then, of course, historically, we suffered from criminal activities. Tombaroli is an Italian term. We have exported, so tomb raiders, tomb diggers, tombaroli, Italian words. I'm sure you know this guy, Giacomo Medici. He made headlines because... Yeah. You met in person? He was charming anyway. Charming. And he and Bicchina and a few others ran these big international rings with other international art dealers. And even today, when, for instance, Italy has now an agreement with the United States, which are one big importer state, according to which the United States enforce Italian export bans, which you possibly know they usually don't do unless they have a specific agreement with the source state. These are more or less the measure of the gap between what is declared at export as going into the United States and what is declared at import coming from Italy in the United States. So the orange is the US import, because the agreement only covered very specific archaeological items. So anything from the Middle Ages, Renaissance, whatever, still can go, because when you are entering it into the United States do not care to ask for an export permission. They do only care about custom declaration for tax purposes. If you declare it, you are okay, and the item is legally in the United States. And Medici is also a good example about how the core element in the trafficking are actually the white collars. Okay, Italy has a long tradition of tombaroli on the ground who are, like in other countries, common criminals, sometimes in countries in war like Iraq or Syria or the like. They are not even professional petty criminals. It's a situation of need. Anyway, these people on the ground, be them professionals or not, they make the less money. Estimates say about 2 to 3% of the market value, and they destroy knowledge for a very small amount of money in absolute terms. The ones who make the trade really possible and successful in economic terms are the so-called Janus figures. So people who know perfectly well that the items are coming from a criminal, unlawful origin, and are able, because they run a legitimate activity, to introduce them for the first time on the legal market. And afterward, we have the willful blindness or the negligence in the other professionals in the art trade who anyway enable the trafficking, but without some key figure like Medici or others, the system could not work. So, for all these reasons, it's not surprising that Italy not only had a huge body of internal law, but was also one of the states actively negotiating the main treaties, and then one of the states who ratified them quite soon, usually after adoption. So I'm not going through the list, but if you look at it, basically Italy has negotiated and ratified all the main treaties. Nonetheless, it must be said that even if we are good at international police cooperation, investigations, and so on, Italy has long followed sort of double standards in these matters. The situation is only now slowly changing. So for instance, we always had these strict export rules, even criminal offenses. We have almost no import rules. Presently, we have no import obligations. We are going to have to implement the European Union import regulation by the end of this month. But otherwise, in Italy, if you look at the Code of Cultural Heritage that I mentioned to you, you find one article, Article 72, that says you are the would-be importer, you are free to ask for a certificate of lawful import. It's not an obligation. It's in the interest of the person. So if the thing is certified as having been imported, cannot be declared part of the national cultural heritage, cannot be subject to export controls, prohibitions, and so on and so forth. Also, we have these strict rules about public ownership, inalienability, and so on and so forth. Also, very strong involvement of police authorities. The Carabinieri are 350 people, all devoted to investigating art and cultural property crimes, mostly in order to recover what was stolen or illegally exported, so working in the interest of the state. On the other hand, when we look at what Italy is doing or not doing when addressing injustice, it is an active part. The situation is less enthusiastic, less good, because we have no structured approach to colonial takings, and Italy had colonies for a short time, but it had. We have no structured policies to help the recovery of private item looted from private individuals, the Jews during World War II. So there are no committees or other system like in other countries. The situation about import is changing because of our European and international law obligations. So now we have at least a criminal offense of unlawful import, meaning that if you import in Italy something that was stolen or anyway was the object of a felony in a different country, or was illegally exported from that country, or was illegally excavated in that country, that is a criminal offense. So still no import controls, but a criminal offense if you are importing items of criminal or anyway unlawful origin. And then obviously we will have to implement the importer statement and the import license measures in the regulation of the European Union. On the other hand, we have two working groups about colonial items and about items taken from Jews since 1938, which is the year where Italy adopted its own anti-Jewish laws. They are not proper committee, they have no advisory powers like in other countries. They do research, basically. Research on collections or research on problematic items without any public funding. So the situation is not so good. So we actually managed to return some items, the Exum obelisk, the Venus of Cyrene, possibly you have heard about them, but restitution occurred in 2008, but basically based on constitutional provisions. Because the Constitution obviously is more important than ordinary laws, even laws about inalienability and the like. So the Axum obelisk we returned because it was an obligation in a treaty we signed with Ethiopia in 1947. And we complied with that obligation and with our constitution that say we are mandated to comply with treaties in 2008. In the case of the Venus of Cyrene, the things were not so clear-cut because the agreement with Libya was not possibly properly a treaty under international law. So in the end, the Council of State applied a different part of the constitution, the one that says Italy has to comply with generally recognized rules of international law in order to support the restitution. But we still need structural changes to the national legislation that would ease restitution in such cases, and we are not even in the process of adopting them. Now, step back to introducing into the market the antiquities or the artworks that are stolen or illegally exported. Obviously, this part is the part most important for laundering the cultural property. You know that differently from other markets, the art and antiquities market is perfectly lawful in and by itself. So it's not even possible on one hand, but also advisable on another, to use the same legal tools, including criminal law tools, that we use against completely illegal forms of trafficking, like drugs, weapons, human beings, or the like. That probably wouldn't work, but is sure that the practice of the market and also the general low level of due diligence regulation in the market allows for a very easy introduction on the legal market of items of clear unlawful origin. Also because it is customary, you open a catalog, provenance, collection of a Swiss gentleman, private German collection. This is the standard. And since nobody considers it strange, it's extremely easy to introduce something that cannot have any lawful provenance on the market, because even items that maybe are perfectly legally on the market have this kind of provenance. And of course, it's not good even sometimes for the buyer, because you possibly know about the Museum of the Bible in Washington. It made headlines several times because they do follow this practice of acquisition without caring too much about provenance. And they ended up with both thousands of items they had to return to Egypt, Iraq, because it turned out they had been recently looted, but also spending millions of dollars for Dead Sea Scroll fragments that were fakes. Because obviously knowing the provenance also protect you from buying fakes and forgeries, but nonetheless, the practice is often this one. And so it is rightly being said that it's not so much an issue of organized crime in the traditional meaning, the mafia-like organization in this field. It may happen, especially on the ground, or especially in the smuggling phase, the first export from the country, that mafia-like or organized criminal gangs are involved. It's not needed. Usually these trafficking are networks of people who know each other more or less well, and they make agreements on the spot according to the needs each time for an item or a batch of items or whatever. So the problem is, as it has been said, the market is in and by itself both organized and criminal, because a lot of items work. So we will see that, for instance, in Italy, we don't have a criminal offense of trafficking in cultural property, like we have, for instance, in trafficking in drugs or trafficking in waste. We have many, many different offenses covering the different links in the chain of the trafficking, which may seem more complicated, but actually, according to me, it may work better, because parts of the activities are legal, parts are illegal, or anyway, you may happen having evidence only of the unlawfulness of some activities and not of the entire item. And the case of the Lysippos bronze is a good example, because in the end, Italy was able to enact confiscation based just on one aspect of the story that brought the athlete to Los Angeles. And here it is. We call it the Fano bronze, the athlete of Lysippos, the victorious youth. Obviously, internationally, it's known as the Getty bronze. And this is a very interesting case to discuss both Italian law and the practicalities of trafficking and a lot of interesting things. So please, if you have any curiosities, we can go jump back and forth. What happened? The story starts in 1964. And it has not yet ended because, as you know, the statue is there in Los Angeles. And the Italians were also not feeling too well when there were the great fires in California these years, because they were fearing it would go destroyed. Fortunately, it did not happen. Keep in mind this. It was for sure found by an Italian fishing vessel and carried on board. But we are not sure today where it was found. That is, in the Adriatic? Yes. In Italian territorial waters? In international waters? We cannot know, even today. Even the fishermen were not sure that at the time it was very common not to care whether you were fishing in national or international waters. So even they, when they say we did not know, probably they did not know. They are not lying. Now, this is very important in a way, because if it was found in national waters, legally is one thing. Was found in international waters is quite a different thing, because if it is found in national waters, all the rules of Italian cultural heritage law applies. And these rules are basically the same. You see, I've not replicated it for all provisions, but usually what was, at least in the 1939 law, is still present today in the Code of Cultural Heritage. And in the case of blanket public ownership over archaeological findings, this is true since 1909. So, if it is found in national waters, is publicly owned, and as it is publicly owned, is assumed to be cultural property, subject to all the legal protections for cultural property under Italian legislation. Only if and when later the public administration, the ministry or the superintendency, makes an exam of it and decides it has no real cultural relevance, that is called negative verification, and from that moment on, that item is not legally cultural property anymore, so it can be sold, whatever. But otherwise, it is cultural property in a legal meaning. There are also other implications. If we are speaking of archaeological heritage within the Italian territory, there are very strict rules about searches. Searches are reserved to the ministry. Only the ministry can grant permission to other entities, which is customary. They do it all the time. They give the permission, they also give instructions to be complied with. Making researches without prior authorization or going outside the instructions, the orders, is a breach which is a criminal violation. Also, if you happen to not look for, but chance find anything of archaeological possible relevance, like in the case of the fishermen, you have a duty to report, basically immediately, within 24 hours. I don't know if you know the United Kingdom Treasure Act, apart that the duties to report refer to a very small portion of what we consider archaeological items, and then you have 2 weeks, if I remember correctly, so completely a different word. If you fail to report within 24 hours, it's a criminal offense. If you report, you are due a reward that can be also in kind. So maybe the state will not pay you part of the value, will give you the item. So there is still a way in which new archaeological findings can legally enter the Italian market. It's very limited in scope, but there is one. Anyway, our fishermen just carried the statue on board, said, oh, wow, this may be interesting. They consulted some locals in Fano who may be knowledgeable. They sold it to a person without reporting the finding, reporting the import, nothing at all. The statue was handed over several different Italian individuals, including, it seems, a priest who concealed it in a tub in his house. And in the end, it reached the international market. Meanwhile, the Italian Carabinieri, the police forces, got word of the finding because Fano is a very small city and everybody was talking about it. So they started looking for the statue, but they were unable to find either the statue or the individuals possibly responsible. Which were at this point the legal implication of carrying the statue on board and on the coast and not reporting it? Well, once again, if it had been found in national water, automatically there would also have been an offense of failure to report an archaeological finding. Nonetheless, there was an infringement of the Code of Navigation that says any wreck should be reported. The time is longer. Going by memory, I don't know if 1 week or more or less, but you should report the finding, and not reporting is a misdemeanor. Yeah.
Sorry, but how is the wreck defined in this law? Because apparently, like a cultural, it seems hardly to be able to be,
No, it's a very broad. It's a very broad definition of wreckage, including items of this kind. So when an archaeological item is found in international water, is covered by that provision, which is very broad about wrecks, that you should report as a wreck, not as an archaeological finding. So anyway, they were committing a crime, one or the other, by not reporting, but they are misdemeanor. So they are very short-lived. The statute of limitations runs very fast on these behaviors. And then the other implication is, well, if it had been found in national waters, another criminal offense committed would have been the so-called archaeological theft. That is already at the time, now it's punished more seriously. It was a felony to appropriate something that you found in the soil or in territorial waters. It's not proper theft because you are not stealing from a possessor. You are the person who discover and immediately take possession of it, but you are stealing from the state, basically. So in that case, there would have been this offense too. And for the people taking the statue, obviously they would be fencers. So there was at the time a general offense of receiving proceeds of a crime, which was not specific for cultural property. It's the one you apply always when some people play fencing for a stolen bicycle or whatever, but that would have been a criminal offense. Now what happens? Only about 10 years later, Italian authorities actually know where the statue is, but it's already abroad. It's in Germany, it's in the shop of an antique dealer in Munich. The Italian authorities try and ask the cooperation of the German authorities for at least seizing the statue. In Italy, meanwhile, was pending a proceeding for the offense of unlawful export, as we will see. The German authorities refuse cooperation on grounds of lack of dual criminality. Export offenses, criminal offenses, are very specific to each country. So there was not like a criminal offense in Germany, and in general, the punishment for the crime of unlawful export in Italy at the time was lower than the general threshold for police or judicial cooperation. So the German authorities did not implement any freezing measure, and the statue was then transferred to the United Kingdom. It was sold in the United Kingdom to the Getty Trust, which then brought it into the United States, where it remains today. On a side note, in the years soon after 2000, Italy started an aggressive policy of diplomatic agreements to get back antiquities from especially American big museums. That was the way in which the Euphronios crater was recovered from the Met. And also with the Getty, the Ministry of Culture and the Italian government were able to strike an agreement. So many items that had been looted from Italy in previous decades were returned, but that agreement expressly stated that it was not about the victorious use, because there was a specific litigation pending at the time, and the two entities, the museum and the Italian government, kept the statue outside that agreement. So this is the practical stories, how it arrived where it is now. Getting back to the judicial history, so a few more legal details. What happened in Italian courtrooms, meanwhile? In 1966, actually, a criminal trial was opened against a few people, individuals, who had been charged with the criminal offense of receiving an item of criminal origin. But the problem is, you must prove the criminal origin of the item you are accusing somebody of fencing. So as it was not possible to achieve evidence that the statue was found in territorial waters, it was not possible to prove that the item was the object of a felony, because not declaring a wreck is a misdemeanor. So there was not enough ground. So these individuals were acquitted, and it seemed that it was not possible also to order a confiscation of the statue at that point. Actually, a prosecutor who knew the law better, in 1933 started a new criminal proceeding in Italy for a different charge. The charge of unlawful export of cultural property outside the Italian borders. It was on that charge that the Italian Carabinieri and prosecutor asked cooperation to the German authorities, who said, but this is not specifically a criminal offense here, and anyway it falls below the threshold for judicial cooperation. Why was it possible to make this kind of very different charge? So not based on an issue of ownership. You were no longer contesting that it was stolen and it was received, but just it was exported in breach of Italian laws. Because whatever the place of finding, it was proven that it had been carried on board an Italian vessel, and then on land in Italy, and then outside the Italian borders. And the Italian cultural property export rules say that you have to ask permission for everything which is not contemporary art. And if you carry something abroad without an export permission, you are committing a crime and a felony. So a more serious crimes, which was at the time punished with very low penalties, but still it was a felony. And these are the rules as they were at the time, but basically they are reflected in today's law, because as I told you, there is really a continuity between the different provisions. So anything which is cultural property in a legal meaning can never be legally permanently exported. So if it is something in private ownership that has been declared by the public administration, or if it is in public ownership, it is assumed to have cultural relevance. No negative verification, permanent export is barred. Temporary export is possible, but once again, it is legal only if you get a temporary export permission in advance, and if you return the item within the deadline of the export permission. Breaching any of these rules makes for a felony. And the other very important specific provision here is that any cultural property which is the object of a felony of unlawful export must be confiscated, even if nobody is convicted for the crime. All that is needed is that it is proven that the object was legally exported. So it's something about the object, not about the individuals who are charged. And it is also clearly stated in the law that in this case, the confiscation is mandatory even if the statute of limitation for the criminal offense has run out. It's a very, very peculiar, and it only applies to illegally exported cultural property, because in other cases, confiscation only falls on something that was a product of the crime, while this is simply the object of the crime, and in all other cases, in order to confiscate, you need a conviction of the individual. So everything revolves around this law provision. So even if those original trial was closed because it was not possible to find the individuals, in 2007, when it was possible to identify some of the exporters, a further trial was started. And this time the judge remembered that, yes, I can order the confiscation, even if, yes, anyway, for the individuals I need to acquit because the statute of limitations has run out. So the trial against the individual was closed again, but there was a confiscation order that was valid and that was confirmed by the Court of Cassation. And this is the provision that was the one who made possible this confiscation. It's the original one of the time in the law of 1939. Actually, this provision was declared partly against the Constitution because it allowed for confiscation even when the item was found in the hand of an innocent party, a person completely extraneous to the crime. So the present phrasing, that is the one that you find also in the translation, which is unofficial that I provided to you, is the one that takes into account also the request by the Constitutional Court to make an exception to this mandatory confiscation only if and when the item that was culturally exported ended up in the hands of a person who is completely extraneous from the crime. But this being extraneous to the crime is interpreted very strictly. So obviously, a person who participated in the crime is not extraneous. But also a person who later, at a later time, benefited in any way from the crime without being in perfect good faith is not considered extraneous. So actually, according to Italian case law, this confiscation apply even against people who are the possessors of an illegally exported items, who did not participate in the crime, and who acquired the object later without paying due diligence at the moment of acquisition. So the Getty fit the picture because the Italian different trials started in the 60s, and when the Getty bought the statue, they were perfectly aware of all the trials, the criminal trials, the requests by Italy. They even paid good money for legal consultancies. And so, in fact, the Cassation confirmed the confiscation order, but the Getty appealed to the Constitutional Court on a matter of procedure. Why? Because the hearing in which it was ordered the confiscation had not been a public hearing. And they were saying, well, but actually you are going to affect my ownership right over the ownership right I say I have over the object, and that should be done in a public hearing. And the Constitutional Court granted their request, and so the hearing was redone with their participation in a public hearing, and the Cassation Court confirmed the confiscation order. So we had, by 2019, a final confiscation order adopted in compliance with all constitutional guarantees. What happened then, that the Getty Trust, as you know, brought Italy in front of the European Court of Human Rights to say this is sort of legal persecution against us. You are illegally infringing upon our right to property as acknowledged in Article 1 of the first protocol of the European Convention on Human Rights. They could, because Italy is a state party to the convention, so even if the United States are not, they were lamenting an infringement by a state party, so they could. And the European Court of Human Rights assessed their position, and in the end, it upheld the legitimacy of the Italian confiscation order. And now we are going to see why. This left Italy in a morally better position, politically better position, but practically nothing changed. The statue is in the United States. Italy has asked for the Department of Justice executing order and has not get it. And I think we will never get the executive order. But the decision is very interesting because it touches on a number of points which are legal but also practical, especially the part of the decision which is quite long about whether the Getty Trust was diligent or not when acquiring the statue. The first point of interest, I think we may ask ourselves, okay, but the court, did it say anything about who's the legal owner of the statue? Yes and no. In legally binding terms, no, because that was not the point. Italian government say they are not the owner, so they cannot act in front of the court, but the court said this is not the meaning of Article 1. Article 1 grants protection to anybody having a sort of proprietary-like right over the thing. So the Getty had long possession for a very long time of the statue. They are the ones who have exhibited it in the United States and abroad. So, okay, they do have an interest to be protected under the convention, and we are not entering into the issue of ownership because it is possible that they legally acquired ownership, considering how many different national laws are involved in the history of the statute. The Italian law, but also the Liechtenstein law, because the company who sold it was a Liechtenstein company, German law, United Kingdom law because it was sold in the United Kingdom, United States because it is owned by a United States entity and it is in the United States. So basically, we are not going to address the ownership issue. So it was outside of the scope of the decision. And even if you read the decision, you get this feeling that they feel for Italy. In some passages, basically they imply that is publicly owned by Italy, but anyway, it is not the object of the decision. So it's not legally binding on this point. But yes, of course, the Getty had a right, a property-like right that could be defended in front of the court. On the other hand, Italy was representing, defending a public interest, a collective interest. And these are the passages of the decision which are very, very interesting when the court stresses that states' right to control the international circulation of cultural property, which is theirs or which they allege is theirs, or anyway, it was in their territory, so it is subject to their movement control. It's a very important collective interest, publicly relevant interest, which compared with other conflicting interests, other interests that may conflict with the interest to property, the right to property and to ownership, can be more important than some others. So the states, or the court reiterates in several passages, have more room of maneuver when placing limits to private ownership rights, property rights, when we are speaking of cultural property. Because controlling the international circulation of cultural property, whether the owner, is a relevant public interest. And so, okay, we have different rights to be balanced, but the balance between the private ownership right and the public interest in protecting national heritage, in principle, is likely in favor of the public interest towards regulating cultural heritage. And it is interesting that, I don't know if you had the time to look at the text, one argument that is used is look at how many modern treaties grant these rights of the state to control their cultural heritage, to keep it for the enjoyment of the heritage community, the local population. So even if actually all these treaties, the 1970 UNESCO Convention, the 1995 UNIDROIT Convention, but even the European Union provisions were adopted after 1964, they are used when interpreting the rule, Article 1 of Protocol 1, and when interpreting the latitude of the balance in favor of the state's right to control cultural heritage. This is interesting because, yes, they do not infringe upon the non-retroactivity principle, but in a way they make a creative use of newer international law. Obviously, there still need be a reasonable balance between the private interest and the public interest. What makes a balance reasonable? First, the fact that the state respected the rule of law when adopting and implementing the measure. So a measure like the confiscation must be foreseeable in advance in its exact scope of application. It must be adopted in the public interest, but we have already seen that this is basically granted because protecting national cultural heritage is considered in the public interest, and the measures must be proportionate to the purpose and the sacrifice, on the other hand, that is asked of the other competing right. The export control over cultural heritage is considered of public relevance in and by itself. That is another important passage. So even if and when the state is not the owner of the piece of cultural heritage, or it is not proven it is the owner, the simple fact of regulating what enters and exits the heritage of a nation is in and by itself worth of protection. So it can be used as a counterbalance to ownership rights. And so even provisions for the recovery of something that was just illegally exported or can be proven to just have been illegally exported, in and by themselves, in principle, are legitimate under the convention. In the case of Italy, it is proven that whatever had happened before, it had been exported without following the export rules, and the confiscation was not a punishment. That particular confiscation has a recovery nature. So followed mostly the purpose of reinstating the control of the state over the cultural heritage it should have been able to control in principle. So not punitive, but in a way restorative or reparatory, it is said at one point. But then, is this measure, confiscation, so taking the thing and incorporating it into the state's patrimony, proportionate? Because that is the other test. Proportionality depends on many things. It also depends on the position of the purchaser. If the purchaser, in this case the Getty Trust, had acquired really in good faith, without knowing or being able to know that the item had been illegally exported, considering that it had bought it, it had exhibited it, probably the interest of the Italian state would have succumbed. But in this case, the European Court of Human Rights says this due diligence on the part of the actual holder is seriously lacking. And once again, what due diligence is in this field is interpreted in view also of the principle set, especially in the 1995 UNIDROIT Convention. So it is not applied because it could not be applied, but is used to interpret the principle, the proportionality. And what the court says is, once again, yes, at the time, the trust representatives had every reasons at least to know that the item was problematic. They asked legal assurances only to the experts by the vendor, so by the selling parties, which is not a very diligent thing to do. Besides, the founder, Mr. Paul Getty, had clearly refused to buy the statue because there were pending doubts, and had said, you can only buy the statue if these doubts are resolved. Going against his will, after his death, the trustees bought on the ground of legal assurances by the same lawyers of the same vendor they had consulted before. So in the end, actually, there is a passage of the court decision that at the very minimum, they were not diligent in buying the statue, but probably they were in actual bad faith. So in a situation of this kind, a measure that takes away the statue is proportionate, respects the principle of proportionality. And the interesting thing is here, going outside criminal law, is whether these passages about the provenance research not done and the eyes willingly shut during the purchase stage of the affair will influence how due diligence standards are interpreted all around the world, also in national legislation. Because after all, the case law of the European Court of Human Rights has a huge impact. There is another element of this case, which in a way I find very interesting, even if it tends not to be stressed a lot. The issue of proportionality of the measure, the confiscation in this case, also depends on the good governance of the procedure by the state. And in this case, it must be said that Italy was not constant in pursuing the confiscation, the restitution of the item. Also for political reasons, whatever, there were years during which the thing was dropped. And the court says, yes, we acknowledge that the Italian government was not always so diligent in pursuing the confiscation, therefore the restitution, as it should have been. But in this specific case, it does not make the measure lacking proportionality, because They were at the time working in a sort of legal void internationally. None of the tools, the UNESCO, the UNIDROIT Convention, the European Union law were applicable at the time. And in any case, probably the statue was theirs anyway, was part of the archaeological public patrimony of the state. So it's different from the other famous Italian case in front of the European Court of Human Rights, the so-called Baylor case. I don't know if you're familiar with it, but it was once again the owner of a painting, if I remember correctly at that time, that won against Italy in front of the European Court of Human Rights because it was a matter of limiting his ownership right. He was the actual owner of the painting. In this case, the fact that, yes, we cannot exactly say that probably it was originally in the ownership of Italy and it was inalienable, weighted. There is, anyway, a number of caveats in this reasoning. First, if we are discussing of measures for the recovery of something that was illegally exported but was actually for sure privately owned, probably this proportionality test would run more in favor of the ownership right. The protection given to the ownership right in the balance with the state's right will be more in favor of the private ownership right. Secondly, for sure in this case, this proportionality test will be harder to pass nowadays, that there are time limitations and other procedural rules clearly in place, at least whenever the object of the litigation involves the applicability either of European directive on the return of illegally exported items or the UNIDROIT Convention or whatever bilateral agreement, for instance. So if a state is not diligent in pushing something that was illegally exported following the procedure, probably the decision will be in favor of the private ownership right. And the balance will be struck in favor of the private ownership right. So you see, it's a judgment on a criminal law provision, but it has implications for a lot of different issues. For administrative law in states like Italy, which rely heavily on administrative controls, for due diligence standards in the market, also in other countries. So it's a case full of potentialities, I think. Need we get back on something? Because otherwise I have just a few hints stemming from this, but not strictly related to the case. So is there anything, curiosities, questions, whatever? Yeah?
I have I'm not sure if it will be a question or more of a comment. And I would not like to sound like a devil's advocate, but yeah.
We are lawyers, we love devil's advocate.
Basically, what is the proof that the statue was found actually in Italian or international waters? Because it could have been found also perhaps in Albanian waters or Greek waters or elsewhere and just transported via this fishing vessel. So
yeah, I have two answers to this. First, neither Albania or Greece raised claims. So the only issue was it found in Italian territorial waters or in international waters? So basically the question remained that one. And the answer of the Italian authorities and of the European Court of Human Rights was, in this case, that was not the issue. Because, okay, we maybe can never solve this point. We'll never be able to solve this point. And so we will never solve the issue of the original ownership of the statue. But forget this for a moment. For sure, it was brought in the Italian territory. It was already basically in Italian territory on the vessel, but for sure when it was brought to the port. As such, it was subject to Italian export rules, which have a relevance all of their own. So a breach of those export rules is worth a sanction of some kind, and the state has a right to claim ownership afterwards over something that was exported illegally. So Italy or any other state is in their full right to say, you are exporting illegally, you lose ownership of the item, because you're infringed on the public interest to at least control beforehand that that thing was exportable or not. So this is a case in which the law grants ownership afterwards as a sort of restorative measure for having gone against the legitimate interest of the state in controlling the export. It could have been the same for, say, a painting coming from France, of which we had no idea about when it had entered Italy. Anyway, it is in Italy now. It has been in Italy for a time, and I want to export it. If I want to export it, I have to ask the export permission. In 98% of cases, permissions are granted, actually. But if I don't, or I export it against a prohibition, that kind of breach of export rules grants the state the rights in and by itself of confiscating. So from that moment on, it becomes part of the patrimony of the state. And it is useful for all these cases where you cannot be sure about the origin of the items, sure.
So in case the Albanians or Greeks or whoever will find some evidence that might come from their territory,
there will be a different question and possibly a different litigation, not necessarily a litigation. Maybe there would simply be an agreement, but if we were to litigate, that would be a litigation between, say, Albania and Italy, in that case in front of a private law court, a private law tribunal, strictly about who's the owner of the statue. Yeah, because in that case, if their laws say something of the kind is inalienable, the private law courts in Italy would have to consider that, even if it was acquired through confiscation. So a lot of work for lawyers, in that case for private law specialists, till now, especially public law specialists and criminal lawyers worked on this case. You're very welcome. Anybody else? Yeah?
So my question relates to what you said about the fact that I think like somewhere around 1960s, 1970s, in one of the slides that there were like these proceedings concerning the misappropriation of property, and they failed because it was said that it was not possible to prove whether the statue was found in the Italian territory, and because of that, well, it was hard to see whether it was the misappropriated property of the Italian state, right? But I'm wondering, could it be possible that, in fact, despite the fact that, well, let's assume that the statue was found in the international waters, in the end, while it was, let's say, found in the nets, it was still found in the nets on the vessel, which was the vessel under the Italian jurisdiction. So in the end, well, the international says that, well, it could be considered, particularly by the state, as a part of its territory. And I wonder if the Italian courts even tried to pursue this avenue of arguing that, in fact, well, if it is found on our ship, it is found in our kind of territory.
They tried, but it's not a very safe route, because there is no agreement about this. And so, especially considering that the trial for receiving was a criminal trial, and you must have all the elements of the offense proven beyond any reasonable doubts, in a criminal law, in a criminal trial, that would have been completely unviable. And yes, the judges were correct in acquitting, because not having evidence of the location of the finding, and therefore of the ownership, and therefore of the misappropriation, was something that make the acquittal absolutely de rigueur. So they could not, it would have been wrong to convict in such a case. And if you were litigating about ownership on the issue of, well, the nets were Italians or the vessel was Italian, you will be opening a nice kettle of fish, of fish, because not everybody agrees on that interpretation. But yes, the Italian public prosecutor tried also that, saying, well, okay, the vessel was Italian, so they were anyway found in Italian territory. I'm not so sure it will work well. The problem is, in the first trial, criminal trial, they forgot the further offense of illegal export. And in the second trial, they remembered the offense of unlawful export, but forgot about the confiscation. So we needed a third trial to have a prosecutor who realized that the point was the illegal export and the faculty, actually the duty of the court to order confiscation even in case of acquittal. So you see, even if we have this huge body of criminal cultural heritage law, our judges and prosecutors are not always so well trained about it and about how to make the best use of it. And it remains a problem today, because I'm reading court decisions applying the new provisions after the 2022 reforms, and I cringe sometimes. I suffer physically. Also because sometimes they expand the application of these criminal offenses beyond what is possible according to the text of the rules. So they are basically convicting people that should not be convicted. And as much as I love cultural heritage, I'm still a criminal lawyer, so I'm against this, obviously. The breaching of the rule of law principle doesn't sit well with me. But yes, we also have a problem with the extreme technicality of these rules. They are difficult to understand and to apply even for law professionals. So this was a big barrier to their efficacy, and it is still, I think, a big barrier to their efficacy even today. And actually, the European Court of Human Rights showed a great level of understanding of a very complicated national legislation, which was not to be considered granted for a start.
And obviously, the question that also which may arise is whether we've got the sculpture of a Greek sculpture.
That was one of the arguments by the Getty Trust, that anyway it's a Greek statue, so it should anyway be Greece to claim it back. Well, maybe I can have a problem with that, considering how many Greek colonies there were in Italy. And also, anyway, it was the same topic used in the reverse to try and deny the Venus of Cyrene restitution by Italy to Libya. The Italian Association of Citizens that sued the ministry, among the other topics, was saying, well, but that is an Hellenistic statue. Libya is an Islamic state, so it's more part of Italian heritage than of Libyan heritage. And the Italian Council of State said this is absurd, because Libya's history is made of many, many things, including the Hellenistic period, so it's culturally theirs as much, at least, as it is culturally ours, but it was found there, so it should be returned. So it's not an argument I would support. In general, it's a double-edged argument.
Maybe just for clarification, because you mentioned that in the system, like the addition to the entire Italian framework, criminal law framework for the protection of cultural heritage, the convention of Council of Europe on offenses against cultural property, how this convention really changed the
shape,
the entire picture, because in Poland we have not discussion whether we should ratify the Nicosia Convention, and in some other countries like in Germany there is so much opposition again, because from the art market lobby, from art market leaders to not ratify Nicosia. In Poland it is more the question of the systemic structure of criminal law rather than art market. But in Italy, how this convention really changed the picture?
It did not completely change the shape. It is a convention that was influenced by a movement by the United Nations Office on Drugs and Crime and the European Union. You know, there is this growing fear that trafficking in cultural property is strictly linked with organized crime and terrorism financing. Even a sort of moral panic, that there are links, but probably not such as to justify this level of calling for criminal law. But it's true that Italy was unable to make reforms that were considered needed within the Italian debate before ratifying this convention. So there were gaps and weaknesses perceived internally. The fact that, for instance, the punishment for illegal export was so low. A few years of imprisonment in alternative to a very, very small fine. So for a white collar that would have never received a prison sentence, paying about 500 or 1,000 euros was a good price to go ahead with his trade. Also the fact that, for instance, there was not a specific offense of art or cultural property theft, so when we were not speaking of archaeological items, and the penalties for the so-called archaeological theft were so much lower than the penalties for ordinary theft. So if I were to steal a bicycle from you, I would have been punished more seriously than for stealing a Greek vessel found in the ground. So there were weaknesses, and Italy has proven itself incapable of reform without external inputs. So much so that the latest novelties came from the ratification of other conventions, the second protocol to the Hague Convention and so on. So in the end, the fact that in 2020, more or less, we had this convergence of internal, very old inputs, pressures, the European Union with the new import regulation that we needed to apply because the first part, the prohibition of importing items of unlawful origin, immediately became applicable. The Nicosia Convention that we had contributed to negotiate and we had ratified gave the push. Another important change is that through the input provided by the Nicosia Convention, we introduced almost criminal, quasi-criminal liability of legal persons not necessarily legal persons in a legal meaning, but corporations and the like, for these offenses, and strengthened measures like confiscation for all other offenses against cultural heritage. Accessory sanctions like professional disqualification, the publication of the sentence of conviction and the like. So all measures that target white collars more. I think that there were many mistakes in the implementation of the convention. The reform was not perfect, but the fact that it induced Italy to shift more towards paying attention to the market side of the trafficking and using measures that are more feared by white collars, I think that is the most interesting thing in the reform. That and the fact that it made us introduce an import offense, so rebalance a little our relationship between the protection of our own national heritage and the protection in a solidaristic way of other countries' heritages, and that is good. And also the fact that we introduced an offense of this is the translation I will leave you, that we introduced an offense of forging provenance documentation. Because before, in 2017, the falsification of documents without public value had been decriminalized. So it is no longer in general a criminal offense. If I falsify a contract, say, it's not a criminal offense. In our field, you can imagine the production of fake contracts of sale, fake invoices, fake insurance policies, on the like, to present an item as good when it is of unlawful origin is very relevant. So there was a gap, actually. So at least with respect to documents meant to support the lawful provenance of an item, it is now, again, a criminal offense to fake or forge them or make use of a document you know was forged or altered or anyway. So that was another very important issue. That, the strengthening of confiscation, because nowadays the confiscation of cultural property, which is the product of any of these offenses, is mandatory, not if there is an acquittal, but in case of confiscation is mandatory. While for ordinary crimes against property is up to the judge. It's in the faculty of the judge. Here it is said, okay, it is mandatory. So if a painting was stolen, it is mandatory to confiscate it, unless it ended up in the hands of somebody completely unrelated to the crime, but it has become mandatory. Also, since we are speaking of archaeology and archaeological artifacts, this is something I'm less sanguine about, but they introduced a further misdemeanor in this field, so giving even more advanced protection to the archaeological heritage, because nowadays, if you are caught simply in possession of a metal detector or a like ground scanner in an archaeologically identified area, and you cannot justify why you are there with the tool, you get punished. That is a misdemeanor. I don't like these kinds of misdemeanors very much, because just being caught in possession of something, but it must be said that it only works in very specific, clearly identified areas, so maybe it has a reason to be there. But the most important thing is what they did against white collars, I think that. So if you, without going through all the materials, but well, these are curiosities. So for instance, there was also a proposal to punish the negligent damage of cultural property in any case committed by whomever, even the owner of the cultural property. In the end, they decided not to, so there is now an offense of intentionally damaging or destroying cultural property, even when you are the owner of the cultural property, but it's only intentional. What happened anyway, that in 2024, the Italian government got panicking about Just Stop Oil and other like activists. And they decided to raise punishments for soiling, not only damaging, but just soiling cultural property. And they introduced the parallel system of administrative sanctions. So like it happens with taxes or market abuse or the like, for the same behavior, you get a criminal sanction and an administrative monetary sanction. The monetary sanction is higher than the penal fine. Problem is that as a general rule, administrative offenses apply indifferently to intentional or negligent behaviors. So they decided intentionally not to punish negligent damage by the owner, but in the end, they ended up having big fines, administrative fines applicable to the same behavior. That is another difference anyway, because before the 2022 reform, if you were the owner of the cultural property and you damaged it, you were only committing a misdemeanor, and you could only be punished in the very rare cases where, through causing damage to your own property, you damaged the entire national cultural heritage. So, okay, if you were the owner of, say, the Venus by Botticelli, which is instead in public ownership, and you managed to damage that, you would have answered of this misdemeanor. Otherwise, in fact, it was very rarely applied. Nowadays, the offense applies to the owner that intentionally damages its cultural property. For instance, I want to renovate my building, which is a listed building. By renovating it, I intentionally demolish a part of it, and so damage the cultural object, and that is a criminal offense. And after 2024, I pay a huge fine even when the behavior was not intentional, but just negligent. But that was not intentional on the side of the lawmaker. It's something that happened. There was a passage in the reform when it was proposed to introduce an offense of trafficking, basically. Fortunately, they struck it out because it was written in a way it would have been inapplicable or anyway in breach of the rule of law. It is also interesting that they carried all the main offenses against cultural heritage in the criminal code this time, which is, in practice, is not so very important. Once you have an offense with proportionate penalties, but it is true that in countries like Italy, France, possibly also Poland, what is within the criminal code is perceived as more relevant than what is outside the penal code. So, yes, possibly this is also interesting. It was in general a good choice, but for two cases. and one is the felony of illegal export. Because I have somewhere the text of the offense. I'm skipping, then maybe we can go back. But go ahead. Here. Here he is. It is. Try and read it. Take a few minutes. Read it. The 518 indices. This one, and tell me if you are able to gather from this text exactly what you must and must not do, what you can and cannot do. Is it a guide about what you really can or cannot do in and by itself, taken in and by itself? So you, for instance, inherit a painting from your grandmother, and you have a home, saying you're Italian, you have a home in France, and you say it would be better hanged on the walls of my friend's home. Can you know what exactly do you have to do from this? No, because you need to read it together with the very detailed rules that you still find in the Code of Cultural Heritage, where you find which are the objects for which I actually need to apply for an export certificate, which are the objects for which I just have to make a statement that I'm going to export it because it is freely exportable, and so on and so forth. And there is another one which is even worse, which is about breaches of alienation rules. That one is really completely not understandable, because at least here you are made aware that possibly you need an export permission and there is some kind of public agency you need to get in touch with. But the provision about breaches of alienation rules is even less understandable. So these are the two offenses that probably would have better stayed in the Code of Cultural Heritage.
Could you explain the risk for non-lawyers? What is the risk of having this kind of provisions within a criminal code, with let's say without a proper reference to the normative framework of another code of the protection? Because this is the real risk, I suppose, to really prosecute.
Yeah. The problem is how Italian case law reads general criminal law rules about mistake on law. Because in general terms, you can never use as an excuse your mistake in the law, in criminal law. So it's your duty to know criminal law and know it correctly. If by your fault you breach criminal law, you will answer even if you did not mean. So there was not a full intent because you were not aware you were breaching criminal law, but you will answer nonetheless. The only possible exception is when that criminal law provision was impossible to know or to understand for everybody, basically. This was a correction that was made by the Constitutional Court. But obviously, in a case like this, the law is all at the very minimum is the same rule that was adopted in 1939. So you should know. It is true that we have another provision in the penal code that says when you are mistaken on the facts because of a mistake on rules of law different from the criminal law provision, you can only be punished if the mistake was your fault and the behavior is also punished as a negligent offense, which in case of export is not. So only intentional unlawful export is punished. And I would say that this is the perfect example. So I exported something without asking permission because I failed to correctly understand the administrative rules about export. Okay, so if everything worked properly, I would be able to play a defense of mistake, because it's not properly a mistake in criminal law, but it is a mistake on non-criminal law influencing my understanding of the fact. Problem is that case law, Court of Cassation jurisprudence, almost never acknowledges this defense. That is Article 43 defense, almost always says, yes, but the rules that were implicitly or explicitly recalled are part of the criminal offense. So it is an Article 5 error, an error on criminal law. So it's better to have people able to know the law, because in the end, the Court of Cassation will say it was an error in point of criminal law, and you will get punished. So at this point, I would have preferred these two provisions to stay in the Code of Cultural Heritage, nearer to the rules you have to know to get an image of what is allowed, what is prohibited. It's not a good idea to have them here, especially as the case law stands as it stands on this point. So that is not very good. Not very good. Well, if you want to have a look at the rule about provenance, I have to get back a little, because another aspect of the reform is to going even more strongly against the laundering, all the steps of the laundering of cultural property. Because if you look at the Council of Europe Convention, the requirements are simpler. Acquiring something with knowledge that it has a criminal or unlawful origin, placing it on the market with the same knowledge, and then the falsification of provenance documentation, which was something rightly stressed by this Council of Europe Convention. If you look at the Italian reform, the decision was to duplicate all the provisions already existing about receiving of criminal proceeds, laundering, employment, self-laundering, in this specific field with higher punishments. And so you have a fencing, an offense of fencing, which is punished more seriously than ordinary fencing. And here is a reproduction of the aggravating circumstances for professionals, which are one of the interesting parts. And then you have these two separate offenses, laundering and employment, with the only difference being the fact that to be punished for laundering, your behavior must possess an attitude to obstruct justice, to obstruct the discovery of the criminal origin of the items, while employment is just using the item in economic or financial activities, basically almost anything. So this is the one most similar to placing on the market, full stop. The other one requires that you, in one or different ways, conceal or attempt at concealing the criminal origin, which in this case can be done either through several operations on the market. Medici was a specialist in selling and reselling at auction through front companies and the like. But as you know, if you work in the field, it can also be done, unfortunately, by operating on the item. So smashing it and then restoring it, cutting a painting, whatever. All kind of awful things. Changing frames, adding a candlelight, whatever. And then there is also this other specific offense in parallel as the ordinary offense, that is the so-called self-laundering of items of criminal origin, in this case of cultural property, because this is a peculiarity of Italy. There are like situations in other countries, but for long decades in Italy you could not be punished for laundering or employment of criminal proceeds if you were the one who had committed the original criminal offense. So if you are the thief, you cannot be punished for laundering if you later, for instance, paint the bicycle to resell it to your friends and then resell it to another person or whatever. Why? Because the reasoning of the Italian lawmaker was, okay, but if you committed the crime, it was because you wanted to profit from it. So everything you do afterwards, pursuing that profit, in a way, it is natural. It is covered by the sanction. You should not be sanctioned twice for committing the crime and trying and profiting from the crime. Once again, due to international inputs, all the anti-money laundering initiatives Italy had to comply with, and then we introduced a different, separate offense of self-laundering or self-employing. Includes everything, also the simple employment, which is punished slightly less seriously than laundering. So that was replicated for cultural property too. So if you are the thief of the painting and you yourself launder it, this offense apply and not the other one, which is punished slightly more seriously. And in this field, also the offense of counterfeiting provenance documentation falls conceptually, because producing the fake documentation is a way of concealing the unlawful origin and placing the item on the market. So it is important that, as I told you before, this offense was introduced. It covers basically everything, because it also covers, you see, the alteration of an original existing document that can be used and is used to prove the provenance, and also the destruction of suppression. So if there is something that, for instance, proves that it was in that gallery and therefore it was stolen from that gallery, and you destroy it, that falls within this offense. If you are only the user, so somebody else produces the document and you are only the user, you are still punished but slightly less. And this is how also the the existing offense in the past were structured, so they had been decriminalized. When they introduced it in the field of cultural property, they decided to keep to this distinction. But actually, since we are speaking of laundering, even the offense of unlawful import, in a way, consciously or unconsciously, is understood by the Italian lawmaker as part of the laundering process, because it is true in our field, bringing the items abroad and possibly having them sold and resold in different countries is an important part of the laundering process. And so you look at Article 518 ditches, that one that was newly introduced about the unlawful import. It follows quite strictly the structure of the provision in the Nicosia Convention, but there is this starting clause. The offense applies except in case of participation in the receiving, laundering, employment, or self-laundering of cultural property. So it is understood that importing can be part of the laundering process. So if it is, you should not be punished twice. Only those offenses apply which have higher punishments. If it is not, or you cannot prove the other offenses, you can only prove the unlawful import. Anyway, there is the offense of unlawful import that covers anything imported that comes from a felony. So it's not just something stolen. It's something that was the object of any kind of serious crime abroad, or the import of anything discovered as a result of unauthorized archaeological researches whenever an authorization is required in the country of origin, which means that in this case, maybe there was only an administrative offense. It's not required that it's a crime, make archaeological unauthorized excavation. It's enough that they were excavated without authorization, and the same is true for things that were exported in violation of regulation of the country of export. So even if that is just an administrative offense in the country of origin, that is enough. And this strikes, according to me, a good balance and brings back in Italy from a situation where we were not in the club of the most solidaristic countries, because before the reform, we were in the situation in which we only protected basically our national heritage. So export was strictly controlled and breaches of Italian rules were sanctioned, but we did not care. There was no specific offense for import of something illegally dealt with abroad.
We can just add this was also the Polish case, no?
But it's very common, actually. It's very common.
So only because of the implementation of the EU law or regulation of import of cultural goods, we've got in our legislation on our act on the protection and the care or guardianship of monuments. We've got a special provision, criminal provisions on illicit imports, which was not the case in the past. Because this was also like a critique of many countries, like not being part of the common market, that the EU really protects the national treasures of member states,
Yeah.
putting much control on the border when on the exit from the EU,
and not on the entry.
Not really, and so the EU was a big like the laundering place of the globe for illicit objects, especially from Middle East,
Sure.
and Northern Africa. And this now, like after 2019, and I think this year we should also have the new system for giving the provenance document documents, you know. I think should
Yeah, I don't know if you know anything about it, because actually it should be implemented. The implementing regulation has been adopted a couple of years ago. And anyway, the provisions about licenses and statements are becoming applicable by end of this month, but
yes.
I've not
Not
heard
very
anything about the activation of the electronic
because,
system.
Because the law should be like a electronic system where all these documents, as I said, should be visible, so it should be available to the national customs officers and so on. But for the moment, silent. But this is like a huge step, not to really block the flow of objects from outside the EU. But it's true that in Italy and Poland, these import criminal sanctions were only introduced after the
External
push
imports.
from the EU.
Yes. Probably, I don't want to give it a malignant interpretation, meaning that there is a resistance to change. The legal tradition started even before the unification of Italy, in our cases, with export control provisions. So we were blinded, and we didn't even see the need for import controls or import sanctions. But anyways, in the end, it was unsustainable in practice, because Italy and many other European countries were so easy place to launder items from abroad, and in policy. Okay, we are spending millions of euros on protecting our own heritage. We should support better the other countries who legitimately want to protect theirs. But I think most of the time is a question of laziness and the habit to have laws, except with market countries. Yes, of course, we look at the United Kingdom. It is for sure not a case that in the dealing in tainted cultural object offences act, the offense covers dealing with objects illegally taken away and so on and so forth, but the only behavior that is for sure left out is dealing in objects that were just illegally exported. So if they were exported by the owner, or it is not possible to prove they had been previously stolen, looted, just that they were illegally exported, they are not covered, for instance, by this criminal offense, which anyway has been applied twice, to my knowledge, since 2003. That is another problem. But okay, from a market state, I do not expect anything different, really. From states like Italy, France, and others, I expect more. Some of them were quicker. France, anyway, introduced an import offense only in 2016. Germany only when they reformed all the cultural heritage legislation in the same year. Italy later, but anyway, now we are also covering the import of something that was illegally dealt abroad. The punishment is slightly lower still, but the idea is that, yes, we care also about protecting another country heritage. It will not be an offense easy to prove in a trial, because it's intentional. So you must prove intent about everything, so also the full knowledge of the importer that the item was illegally excavated, illegally exported, was the object of a felony abroad. So it's not easy to apply. But in some instances, it can be possible. But the electronic system we were discussing before would be far more important. Yeah, far more important, because it would make at least one point in time when through all the European Union you can keep track on items. And that would be so important.
Because just now I think that's like the last maybe 10 minutes for maybe the final questions, final comments from we need to conclude soon, very soon. So if there are any additional questions or comments also from those of you who work in museums and dealing with provenance issues, so some final comments, remarks, also maybe from your practice, I don't know. Is there anything that you would like to ask or add?
I would have a question because let's say that this is one of the many American cases now of this, let's say, sheets of the 60s and 70s coming on the ground. And I was just asking this, we're talking very much about white collars, about the market and so on, but not really much about this upper end of the historical museums. Is there a way for them to save their reputation, all this? And I heard now, I don't know, maybe this is a way about some agreements between museums, university museums and countries to keep the objects in long-term loans.
Mm-hmm.
Do you think that this is a way? This will be like, maybe this will go in this direction? I don't think about the Getty, but about this museum which make use of this object for education and so on, because you may think, of course, like I'm observing also Poland, who is really really reluctant to regain the war losses, and then this war losses end up in deposits. So this is also the question about okay, are we just fighting for the rule, or what about this heritage?
No, I think that actually in many cases negotiations would be the better way, and also possibly maybe in a more structured framework of guidelines for possible solutions, so that not every new negotiation starts from scratch, but you have a good list of examples of what was done and worked in previous cases, because it's true. Sometimes it's even legally impossible to reach a solution through litigation because of the running out of statute of limitations, lack of jurisdiction in the country where you are bringing the claim, or whatever, the fact that the item was sold in a country like Italy, by the way, who grant ownership to the good faith purchaser, because Italy is paradoxically, for instance, this is the rule in Italy. So there are millions of reasons why sometimes litigation will bring anything. Legally speaking, it would be impossible to give back the item. And so to have more structured initiatives, also covered, for instance, by the International Council of Museums or the like, to negotiate more and more creative solutions like long-term loans, exchanges of items. In some past cases, even production of replicas has worked, whatever, because in this case you can also be creative, so not just giving back or not giving back, but many other solutions. That will be better. And I feel it, especially as a criminal lawyer, because in criminal law, it's a zero-sum solution. You are either guilty or not guilty, convicted or not convicted, and you cannot do these kind of things in criminal law. But when mostly the issue is a private law issue, ownership, okay, it should be more implemented in a solution of this kind. Alternative dispute resolution, possibly with more awareness about restorative justice methodologies. So not a purely negotiational approach, but knowing a bit about what even the United Nations are promoting, so restorative justice in this field with such a symbolic, identitarian, sentimental implication are questions about cultural heritage. If it were possible to structure a system of negotiating, but within the framework of restorative justice, that probably would be the way to give more satisfaction to all the involved parties, and also to allow for items to be displayed that today are closed, locked up for fear of scandal, litigation, and whatever, for sure. We are missing out on so many important things that are locked up in Cabo, also for this reason.
I have one more question. Does Italian law says anything about hiding of provenance by institutions?
Not exactly, no. Meaning that there is not a duty of disclosure, say, if this is the object of the question. There is not such duty of disclosure. The few initiatives that I mentioned, these two tables, working groups within the interministerial group for restitution, are meant to improve transparency, because actually their only real task is to do provenance research, to support provenance research. They are anyway in the hand of the government. So the present government decided not to revoke them, but it is possible that in future a different government will revoke them. They are not funded. They have to apply for grants outside or ask for the support of the museums or libraries they are working with. So there is not a formalized duty about transparency on provenance. And even if there are a few efforts, they are not very supported. This is the situation presently.
Sounds like our situation.
Sounds like ours.
As far as I know, it's very common in the majority of countries all around the world, which is not good, because anyway, this kind of provenance research is anyway needed for scientific reasons. So why not profit from it also to redress some historical torts when it is needed? Anyway, it will carry with it the scientific knowledge we need. So there are only good reasons to do it and not really good reasons to not do it. But it's hard. Governments don't want to spend money on this, for sure. I can even see why they don't see it as a priority, but at least the most egregious cases should be addressed at the very least, the most egregious one. Yes, but yeah, but it's not a very rosy picture, I know.
Thank you.
You're welcome.
Thank you, Arianna. Thank you, first of all, for making law very clear to us. It was a very clear speech, and this is always difficult. And I'm also very happy that we also made some comparisons with our own situation, and this shows how it is so important to tackle such issues as provenance research as a general news, not also in wider frameworks. Thank you so much.
Thank you. Thank you.